The Americans with Disabilities Act of 1990 established the right of handicapped people to equal employment opportunities in the workplace. The act applies to um, employers with 15 or more employees, and also to federal agencies and recipients of federal funds. Now, the right of disabled persons um, to enjoy employment on equal terms was established already in 1973 in the Rehabilitation Act. But that act established protection for those persons on the federal level. It wasn't until 1990 with the American Disabilities Act when those protections were extended to disabled persons on the state and local government levels, and as I mentioned before, to private employers with 15 or more employees. To establish a viable claim under the ADA, a plaintiff must prove by a preponderance of evidence that, one, he or she has a disability in a corrected state. Two, he or she is qualified for the position despite that disability, with or without reasonable accommodations. And three, an employer discriminated against him or her solely on the basis of that disability. Whereas point three is quite obvious, I think point one and two require a little bit of qualification on my part. So number one, plaintiff has to prove that he or she has a disability. So we need to define here what disability means under this act. And the clear definition has been established as a mental or physical handicap impairing major life activity. Now, the mental and physical handicapped can come in many forms. We have to remember that pregnancy is included here, contagious diseases are included here, even alcoholic and drug addiction are included under the definition. However, we have to remember that nobody is protected from the consequences of their behavior. So if somebody acted silly under the influence, they have to face the consequences of their behavior. Another aspect of that definition has to do with the fact that disability is evaluated in a corrected state. So what do I mean by that? So for instance, a company requires a 20/20 eyesight. Well, a person may not have 20/20 eyesight without glasses, but with corrective lenses, such as glasses or contact lenses, they can actually reach that goal. In this case, the potential plaintiff may have a case, and that would be defined as a disability and would be evaluated in a corrected state, meaning that if the person was discriminated against based on that disability, well, the plaintiff could have an easy case of proving they have a disability, and they should be given an equal employment opportunity because that disability can be corrected by, for example, glasses. The same thing we may think about hypertension, which can be corrected by appropriate medications, and and we have to remember, however, that companies always have that BFOQ available to them, that business necessity, legitimate job qualification. So, for example, we can envision a situation, for instance, a requirement for the airline pilots to have 22 vision without corrective lenses, because we can envision situations where excuse me, where lenses can pop out and then during the flight, and then of course, what are we going to do? And number two, the plaintiff has to prove that they can perform the job despite the disabilities, or in other words, he or she can perform job's essential functions, keywords, essential functions, with or without reasonable accommodations. So now, of course, here the keywords to be defined are the essential functions. And employer is not obligated to make accommodations that would be undue hardship on the employer. Number two, would encompass changes in essential job functions. So employer does not have to change job in its essence. Three, would require employers to create light duty positions as a form of reasonable accommodations. So again, an employer is not required to create lighter duty jobs as a form of reasonable accommodations. So of course, here we can debate what reasonable accommodation is, and of course, in reality, that's quite relevant, and here, of course, we would have to use again a reasonable person standard. So, for example, buying or purchasing, the requirement of purchasing a $500 card might be quite reasonable expectation from a huge company such as Walmart, but it may represent an undue hardship when it comes to a small mom and pop retail store.